Whoops. There we go, folks. I'll get this straight one of these days. Welcome to our Friday edition of Ask a Lawyer Live. I'm David Brannen, employment and disability lawyer at Resolute Law. Today, we're going to have a special guest in, Lisette Leblanc, who is a lawyer with Resolute. And she works primarily in long-term disability. In fact, she does more mediations than anyone in the law firm by a long shot. So I would like to bring her on in a second, but before I do, so our topic today, just to be clear, is we're talking about mediations, what they are, how to prepare for them, things you need to think about. This will be good for anyone in a long-term disability case if you're just curious about what happens at mediations, or if you happen to have a mediation coming up, I would encourage you to discuss it with your own lawyer, but we'll at least give you an overview here as well. As you know, this is a, whoops, I got something on the screen here that shouldn't be there. There we go. So this is a weekly show that I'm now doing Monday to Friday. Fridays are our guests like we're having today. And next week we'll have our topic on CPP disability on Monday. I'm going to be talking about how the CPP disability benefit is calculated. So the formula that they use. And on Tuesday, I've got a very good topic that people will be interested in. It is going to be called questionnaires and surveillance. So insurance companies often send out these questionnaires in advance of doing surveillance or at the same time as doing surveillance. We just had another one of these issues come up, not for one of our clients, but for someone who was contacting us. So it kind of refreshed in my mind how important it is for people to be aware of this and the pitfalls that come through it. All right, so I'm going to bring Lisette on here and we're going to start our questions. So Lisette, welcome.
Hello. Nice to be here.
Yeah, absolutely. It's good to have you here. Lisette and I talk a couple times a week. We work in different parts of the country, but we do always touch base a few times a week. But it's always good to have a conversation like this. So Lisette, let's just start by telling the audience just a small bit about yourself, just so I've already told them that you work with the firm and that you focus on long-term disability, but is there anything else you can just say as a quick introduction?
Sure. I've been practicing for quite some time now. I was in-house for about 10 years with one of the large insurance companies.
Yeah.
So I do have a lot of experience on that end. And then about 7-8 years ago, I did switch. I left the in-house environment and started working with David at Resolute Legal. So for the last 7-8 years, I've been doing this on the plaintiff side. So I am very familiar with how insurance companies work, insurance policies work, and have all of that background. And, now I work to use that experience and knowledge that I learned to help everyone navigate, because I know it's very complicated. It's difficult. There's an imbalance of power as well in dealing with these insurance companies. So I try to bring what I learned to help out, just anyone who's dealing with an insurance company or an insurance issue now.
Yeah, absolutely. And I will just clarify, in-house, that means she worked with insurance companies. Some of them, the big ones, they will just hire their own lawyers internally rather than hire an outside lawyer. So by in-house, she was their internal lawyer doing these cases. She and I actually worked against each other on some cases, and we always had a good relationship. It's very valuable to have someone who has seen both sides, because the danger is, if you're a lawyer like me who's only ever worked mostly on one side, I've never worked on the other side in long-term disability. I did a bit with car accident claims when early in my career, but it's very valuable to know from the other side, because there can be a lot of demonization and assumptions that quite often do not turn out to be true. And so working with Lisette's really opened my mind to think more holistically and broader about, okay, what's really the motivations here? What's really going on? And it really helps for a lawyer to have that kind of experience. So let's dive into the questions here, Lisette. I'm going to bring up the first topic is, could you just talk a bit about what is a mediation? What exactly is a mediation in the context of a long-term disability lawsuit?
Okay, so we've got people from all across the country, and so every province is a different jurisdiction legally. And so the rules are different in every province. In some provinces, some jurisdictions, mediation is required by the rules of court under the system that is in effect in that province. In some provinces, mediation is not required. So there's different types of mediation. If it's mandatory mediation, it means that the rules of court impose it on the parties that are litigating, that are in, started a lawsuit, that they have to go and they have to attend mediation. And often in some provinces, there's actually government mediators that you have to use. In other provinces, even though it's mandatory, you can agree to use whatever mediator you want. And then in some other, third set is there are no set mediators. There's no requirement for mediation, but most of the large insurance companies recognize that it's probably not in their own interest or in the interest of the clients, the insureds, of going through the full a full trial in front of a judge or a jury, and instead attending these mediations. So, David,
that's a great overview. Yeah, how is it different, Lisette, from what's the difference between a mediation and going to court or trial? That's for someone who knows nothing about it.
Yeah. It's all part of the same process. So a lot of people might be familiar with appeals, internal appeals. That's the first process when an LTD claim is not accepted, is going through an appeal process. And that goes to the same group or same department within the insurance company. And then they review the information or review new information or new medical documentation and make a decision. And so the next step, if the appeals don't work, is going to court, the court process. So the court process involves, suing the person, proceeding through all of these processes. And excuse me, at the end of the day, you may end up showing up in court before a judge to decide. And the judge is the only person. They listen to your evidence, they listen to the insurance company's evidence, and they make a decision, and that decision's imposed on the parties. And it doesn't matter how they interpret it. There are, of course, certain parameters that judges have to follow, or juries, but generally that's the final decision on the courts. Mediation, on the other hand, has kind of evolved, and as I've explained, some have included mediation as part of the litigation process now. But mediation is where parties agree. There's generally not, you're not required to attend, but the parties get to choose who they feel that they're comfortable with, who the mediator is, which is an impartial person who doesn't take either side of the dispute. They're just there to see if they can help the parties resolve their disagreement. And then at mediation, it's much more laid back than any other process in the court system. But the insurance company provides what their reasons are that they won't pay the claim, and we explain why it is our position that the claim should be paid. And the mediator just tries to see if they can find areas where we can both agree, maybe not agree on everything, but enough to come to a resolution of our dispute. And if that's not possible, at the end of the day, my client and us, we can tell the insurance company, we're not happy with what you're offering, and we just choose not to settle today. And the mediator cannot impose a decision on each of us. That's the big difference.
That is the big thing. And some mediators will often open up by saying, the good thing about today is you get to make a decision and control the outcome. You can decide to accept an offer or not accept an offer, because there'll usually be an offer there for you to accept. It's just, is it going to be enough that you would want to take it? So you can control the outcome versus having an outcome picked for you. And if anyone, I learned early on that, because I lost a bunch of my first few cases in the early days. One of my cases I lost against a contractor of all people in a small claims dispute. But I learned early on, like, just going to law school and thinking you're smart is not a way to win cases in court. It's often very strategic, and practical knowledge is very important. And you also learn that a judge can just make a decision that makes no sense, to you anyway. It makes sense to them, but so you lose all control over the outcome, and it can. There's some benefit to being able to control what the result is, even if it's not the optimal result, I guess. I don't want to ramble on too long about that, but Lisette, can you tell us, just break down who attends a mediation? Like, when you go there, who is actually there? Like, who are the people that would be at a mediation?
Okay, there's at mediation, there's of course the mediator. So there's a lot of mostly lawyers or ex-practicing lawyers that have built a practice. So they used to practice in this area as a lawyer, and then they've become mediators basically on a full-time basis. So they will be there. And as I explained, they don't take the side of the insurance company or our side. They're impartial, and they're just there to help out. They're kind of a referee in the dispute. And then I will be there. My client, so if any of you guys do work with us, you would attend with me. So there'd always be both of us. And then for the insurance company, there's always a lawyer representing the insurance company. And then there's a person that they call the representative of the insurance company. And that person has the authority to settle or not. The lawyers do not have the authority to settle. The lawyer's there to advise and provide legal analysis and repercussions to any decision that you make, either on the insurance company side or my side. And it's the same on our side. I, at the end of the day, will not tell you, you have to accept this or you can't accept it. At the end of the day, the client has to provide instructions. And of course, I will say, I would recommend this or I do not recommend it. But ultimately, you as the client have the power to decide the outcome of the day.
Yeah, exactly. I'm going to move on to I've got a bunch of topics here to cover. So we're going to come back a bit more to talk about what happens during the mediation. But before we get to that, I'd like to just shift gears and talk about, when does a mediation happen? So at what stage of a disability lawsuit will mediations happen?
Mediations, we need to get to a point. It's all different, but the point at which I will feel comfortable agreeing to a mediation is once all of the information and the medical documents have been exchanged and we have a clearer picture of what's going on. So sometimes if we did mediations right at first, let's say you guys hired us or some other lawyer, and you say, well, I want to go to mediation because I want to get this resolved in the first 30 days because I don't have any income and I just want the money. If we don't have the information, and if the insurance company doesn't have the information and the time to review it, then it's too early and we won't resolve. They'll say, well, we still have questions about this or that. And then the same, if you do it, the same thing. So as it progresses, typically, if we want to give out timelines, it probably is closer. It's going to take 9, 12 to 15 months to get to the mediation point by the time we go through all of the steps, because there's rules of court which protect us and give protections to the insurance company. So any party that's in the courts have rights, and we have to follow all of those steps and make sure everybody is entitled to, their fair shake at this dispute. And so it can be too early. Sometimes insurance companies, I've seen it all. So sometimes insurance companies, we provide a bit of documentation and they say, look, based on what we see now or based on a new set of eyes, we want to talk settlement very quickly, and it can happen in, a short period of time, in a couple months or something. But those are very exceptional, and that's not typical. um, Typically, once the insurance company gets to the point that they have all the information that they need to make a decision, and the same with us, because we need your file from the insurance company. We need to know what the policy terms are. We need to review all of that, how much you're entitled to, how your disability is progressing is also a factor in deciding when to go to mediation. Because let's say you're under investigations and they're not sure what your diagnosis is and they're changing your medications. And if we go too early, you may settle thinking your condition is quite mild and will resolve within, a short period of time. And as things progress, it might turn into, 6 months, 12 months later, your doctors start to say, you may not be able to return to work
Exactly.
again. So if we settle it too early, you would be missing out. And of course, at one point where we see that it's all, we have the information, we know, we have a general idea what the prognosis is, because no one can predict the future, of course. But once all of that seems much at least, at a point where it's clear and we can make a fairer decision, that's the point. So it's hard to give a timeline
Yeah.
because it's going to be different for everyone.
Yeah, no, I agree. It's funny you say like early mediation is often not a great idea because no one has any incentive to kind of give a concession because a lot of the information is not known. I have a case. I just had a conversation yesterday with a lawyer, a defense lawyer from Saskatchewan. Now, I have not done a lot of litigation in Saskatchewan, so this is a case that I'm working on in that province. And it does appear, and maybe you can correct me if I'm wrong here, but the other lawyer is basically saying that we are not even allowed to exchange documents in Saskatchewan until we do a mandatory mediation that they have there, which seemed kind of odd to me because if you're not exchanging even your basic documents so the lawsuit's been filed, they filed their defense, and when the defense is filed in Saskatchewan, you get a, a mandatory mediation notice from the court. And he's taking the position that they don't even have to provide us with documents before that mediation, which seems to me to be like, how could it ever settle? Like, part of my allegations are like, can I prove things but it's information that only you have. So it's an employment case. It's not a disability case. So that's a strange one. Yeah. I'm not sure
Saskatchewan is the one province that has early mediation,
Yeah.
and they're actually civil servants. So
Yes.
they're professional mediators, but they do every kind of mediation. So it could
Okay.
be an employment, it could be bankruptcy, it could
Right.
be bankruptcy. There's a few of them that are excluded from it, but it could be family matters. They're not specialists like we often use that only
Right.
do LTD claims. So
So it sounds like the
Saskatchewan
chance
is
of
very
success is going to
different,
be very low. Yeah.
and they're under it's a different philosophy than other mediations across the country. And so you have to attend, and
Mhm.
both parties, there's no briefs, there's no preparation. You just show up. You have
That's what the other lawyer told me. He said, "Don't even write a brief." I'm like, "What?
yeah,
Then what is going on here? This just seems like a bizarro world."
yeah,
Like,
it's a half day process, and they just have the parties talking, and it's kind of this philosophy that, if the parties talk early, maybe they can resolve it, but earlier, like in the process
yeah.
as it goes along. And of course, they've got mediations at the pre-trial end of it, but
Okay.
it's kind of an experiment on the early one, and then you get a certificate that you've
That's right.
attended.
Yeah.
So most of them do not settle, and you have to show up, you have to get this certificate, or you can't continue.
Yeah. He
But
said it
yeah,
right then. That's interesting. Yeah. I've
so
never had one. I've done a couple cases in Saskatchewan, but they never went to full litigation. So let's switch gears and talk about what happens during a mediation. Now, you've already covered some of this, but let me think of a question here. How about take us through like what does a typical mediation day look like for a client? So just take us through from the client's point of view. What does it look like for them on the day of mediation, from getting up in the morning to being done?
Yeah. From my experience, I'll just talk, maybe amalgamate my clients that I've dealt with
Yeah.
over the years. But um, often they're my clients are nervous. I tell them not to be nervous because because the dispute has to do with something that's personal to you. You're familiar with all of the facts, the doctor's appointments, the effects on you. So there's no preparation really to do unless you want to just review what medications you're taking and what doctors you've seen, that kind of stuff, just for your own purposes. Um, but they'll wake up, they come in, it's a long day. It's for clients that are not able to work and not able to sit, um, or or concentrate, I should say, for a full day. It is a really long day. They typically start between 9 a.m. and 10 a.m. And the first part of it will be all of the parties will be on, kind of it's all done virtually nowadays, I should say. There's very few since the pandemic that are in person. And I'll tell you, my clients do appreciate this. It used to be that we'd have to go to a boardroom in whatever city the mediation is happening. And so it's very intimidating to our clients that are no longer working. The insurance company is just another day at the office. So it's not a big deal for them. And now it's done on by Zoom mostly. And then we meet, and all of the parties are on one of these, a screen like this on a Zoom call, with video. And I will provide, the mediator, of course, will start the day. I'll provide an opening statement, and then the insurance company will provide their opening statement. So that's really just, I'm going to explain why it is our position that the clients are entitled to LTD benefits or whatever insurance benefits. And then the insurance company is going to do the same thing, is explain why it is their position that you're not entitled to the benefits that you're seeking. And both parties, the main reason for this is that the mediator needs to be given some background and some understanding of what's going on, particular to this dispute. And then after that, after the first hour, the parties go into breakout rooms, which are private rooms, virtual rooms, where you only see me during the day, and the insurance company, the lawyer, and the representative are in a different room, and we never see them again. The mediator will come visit us in our room and visit them in their virtual rooms. And the point of mediation, insurance companies typically do not want to talk about reinstatement. If they wanted to reinstate benefits, they can do that at any time if they deem it that you meet the definition of disability. So if insurance companies agree to go to a mediation, they're looking for a long-term, for a lump sum settlement. So just a sum of money that would bring the dispute to an end, and that would end the court case in the courts. So during the day, the client gets lots of breaks. Every, let's say 30 minutes or so, you get 5-10 minutes to stand up, sit down, or get a coffee, get food, or get fresh air. And then the rest of the day is discussions with us, and we're looking and we're negotiating with the other, with the insurance company. So that's a general day.
Yeah, man, it can be exhausting. Yeah, I do notice a huge difference. Like when I was at the point in my career where I was doing the most mediations, it was before the pandemic. So most of what I like, it was constantly scrambling, running around, trying to get parking, trying to get up there. It was very intimidating, and there is some value to having everyone physically together. There is some value to that, but I don't know that the value is so much higher that to outweigh the other benefits of a virtual mediation. That's how I would look at it. Now, I will let's take a second here to look at some of the comments. So, Cindy saying, happy to have you on today, and David as well. Thank you for both sharing your expertise and knowledge. Thanks, Cindy. We appreciate you sending us that message. I would tell other people, if you have questions for Lisette or myself about mediations, just put them in the comments, right in the comments. Whether you're on YouTube or Facebook, keep in mind you can ask other questions too. At the end, we'll just open it up to any type of question that people have. Let's move on, Lisette, to the next one. So we talked about what happens during the mediation. We're going in reverse order here a little bit, but how do you prepare clients for a mediation?
Yeah. Before I get to that, I'll get to it. But one of the things I do want to point out about mediations is confidentiality. So the courts are public venues. And so all of the evidence that's provided to judges that's filed with the court is public. So it's really, I always emphasize to clients that by going with mediation, if it's available, if the insurance company agrees to it, it's confidential. And so your information, your personal information, your medical information stays private, and it's not, becoming public, and anybody can go watch it. Anybody can find out, when you were working, when you went off, why, what happened. If you were having difficulties at work, and all of the employment related reports that may exist, and all of that. At mediation, everything is private. It stays within your own control, and it's the same for the insurance company. And this is why they agree to it, because they really don't want everybody finding out about who they cut off, and they get to control a little bit of it. And that's how we can get them to agree to it. So it's also confidential for them. And they'll ask you to sign a document at the end of the day to say that, you're not going to go tell people, you're not going to go on social media and say, I went to a mediation and I got this amount of money, or I got this from the insurance company, or the insurance company said that. You can't talk about it, but it does protect all of your medical and private information from being just public documents in the courts.
Yeah, exactly. It's also, just so people know, mediations and generally just settlement discussions, the courts have got they put a special zone around. The courts want to encourage people to settle these cases. They, in fact, written into the professional standards and ethical obligations of lawyers is to engage in settlement and to try to resolve cases. So we have a professional obligation through our regulators to do that. But what courts have done is they've carved out this zone where they allow you to say things it's almost like you get a pass. You can say things if it's in the context of a mediation or settlement discussions. You can admit things or say things that later can't be used against you. So if you go to a mediation, you could admit certain things. Like you could say, yeah, well, we agree with you that probably, the benefit amount should be this amount or whatever. Later on, they can't, if you change your mind later on, they can't go back and say, before you said this, and they're going to cross-examine you on it. It's not like a discovery where you're giving your testimony under oath. Anything you say in a mediation is basically can't be used in court or used against you later on. Just good to throw that point out there. So when you're preparing for mediation, just in a nutshell, what do you do with clients? What could a client expect if they have a mediation, say, coming up in 2 months? What could they expect from their lawyer in terms of preparing for the mediation?
As you prepare for the mediation, as obviously it's already been scheduled and it's set down, it's really important for you to provide all of the updated information about what treatment and medical records exist. So you have to make sure that we've got or whoever lawyer it is, has all of the updated information, and if not, that we get it as quickly as possible. Because that mediation, one of the biggest hurdles, and we can't, before I say that, so that you don't go to your lawyer and say you weren't doing a good job, but it's impossible to have all of the documents, right? Some people go to their doctor 5 days before mediation. We can't get those documents. There's no way we will ever get them. As long as they're generally up to date, sometimes it's 6 months or most up to date we can get. Sometimes it's 3 months, sometimes it's a couple weeks before. But it's really important that you let your lawyer know where you're at, because we can deal with it in different ways. Even if we don't have the documents, we can at least let the insurance company know that you're attending certain treatments or getting certain medical appointments. And then that's one important thing. Secondly is I or your lawyer will be preparing a mediation brief. And as I said, it's similar to the presentation that I provide at the start of a mediation, but we have to provide within 5 to 7 pages a report to the mediator, and the insurance company does the same thing, so that they understand, they can prepare and understand what is the dispute between the parties and what are the potential outcomes that they can help us craft and come up to at mediation. And so I'll be preparing that, or your lawyer, and going through all of the medical documentations. Your lawyer may ask you for just information to clarify certain points and all of that. And then I'm sure every lawyer is different, but what I will do is have a couple of meetings with you, typically about 3 weeks before the mediation. I'll have a meeting to go over kind of this information, just what to expect at a mediation, and get that mind going. And then a couple of 1 to 2 days before the actual mediation, then I will meet with clients, and often we'll start talking about very specifics about the what we want to see it happen at the mediation.
Yeah, like in terms of how deep do you go? Because this is something lawyers all do differently. How deep do you go with clients on, here are the possible settlement ranges? Here's the risks of if it doesn't settle at mediation. Here's the risks at court that could happen. How far do you go down that road with clients?
I think it's really important to understand where you are, and every lawyer is going to be different. But I'm always very upfront and open, so I try to look at it from my client's best point, but there's always risks. And so I point those out as well. The insurance company is going to see it as a certain way, and they're going to interpret it. And then the judge at court, I will provide as well, if there's case law that deals on an issue, or how would the judge see it? Because one of the things to keep in mind is you may have a condition which prevents you from working, but it's all in how people perceive what's going on. So that someone might have a relative who has the same condition but is able to work or do more than you. And it's impossible to compare, but people have biases and they do it. So you have to keep that in mind, that there's certain people out there that are able to work and may have the same condition you have, but it affects you differently. And in trying to convey that and understand it, insurance companies look more at objective evidence and make conclusions based on that, because how a condition affects someone subjectively is different for every single person.
Yeah, absolutely. Now, I've got a good one for you here, and I'd encourage people, if you have questions, just put them in the chat. Let's move on to the next one here, because I'm interested in your take on this. I don't know if we've ever discussed this specifically, but the way I always think of it, so things that influence the outcome of a mediation. One of the things I think it's important for clients to understand is that, number one, when you go to a mediation, let's just assume we're going for a lump sum settlement. It can only settle for the maximum amount of money that the insurance company will pay. So they have a lot of control over it because my understanding, Lisette, is most insurers come into a mediation with a budget that is imposed on them to say, like, you can go to the mediation and spend up to this amount of money, but not a dollar more. So my view of it has always been that the goal of the other side, that would be the lawyer on the other side and maybe the litigation representative for the insurance company, their goal is always to try to settle under what their maximum budget is because it would look good on them. They're getting out with less money. So my goal has always been to try to make sure that at the worst case scenario, that at least I'm getting them to offer all the money that they came there available to offer. Like I tell clients, like that's really the best I can do at a mediation is to get them to offer all the money that they had available to offer. And then you can decide, okay, will I take this or not? Because in my mind, they do have a cap at these mediations. Now, sometimes they can make a phone call and maybe get a little bit more, but I wondered about your take on that, if you think I'm looking at that correctly or if your experience has been different.
I think every insurance company is different. I think a lot of the insurance companies, the people that they send, the representatives, have a lot of power over making assessments of the case. So I think they come in, they've got actuarial reports, they've got the medical information, they've got maybe employment information, they've got other information. So they look at that overall. And of course, they see your case differently than you do. So even though you think you have a slam dunk case, the insurance company doesn't see it that way. And they're willing to fight for it, or they would be paying your benefits. So the representative has gone through and they've come up with a number. Some of them, it might be imposed by somebody else, but typically, I think they make the decision that this is what it's worth. And what you have to keep in mind is, although the policy says you're entitled to LTD benefits till you reach age 65, even if your claim was being paid, or even if you got reinstated and you were on claim, insurance companies rarely pay those benefits till age 65. The reality is that if you're on claim, they're going to send you to vocational rehabilitation or to a occupational therapist, or to take treatments that you may not agree with and that your doctor may not agree with. And then once they've got you at that, they'll find a reason or an opinion, I should say, that you can return to work in, whether it's some kind of work or at some level. And so it's, realistically, insurance companies, even though we can calculate what that number would be if you receive benefits till age 65, very few people do. And so insurance companies are taking that into account. So when David talks about there's this number, this maximum number they're willing to pay, you have to keep in mind that at trial, which we didn't talk about this, but at trial, if you go to trial, the judge can only or jury can only reinstate your benefits. They can't pay out this lump sum like the insurance companies are agreeing to do. And as David said, mediations are off the record, meaning like everything that's talked about there doesn't go anywhere else. So they're not following the policy. They're looking outside of this contract, and they're coming up with a novel way to resolve it. But if you go to trial, the most the insurance company, the judge can do is put you back on claim. So they would pay the back pay up until the date of trial. But after that, you can go back on claim, and then 3 months later send you to a occupational therapist or to a psychiatrist and say, oh, actually, this psychiatrist or this occupational therapist says that you can go back to work doing X, Y, or Z, and they stop paying you. And you could be back in the legal process. So when they've what insurance companies do is they review your case and they say, based on the severity, based on the medical evidence, and based on all of these things, this is how much we're willing to pay out. And they will never pay you to age 65. I mean, maybe if you're 63 or something, you can get pretty close. But like, generally speaking, they will not pay you, because if they put you back on claim, then they will take every step that there is, whether you agree with them or not. And if you don't follow what they tell you to, then they'll cut you off for non-compliance of the policy, under the policy. And so the amounts have to be tempered. It's not going to be your benefits up until age 65. It's going to be a small portion of it. And that's even if we go all the way to trial and put you back on claim, doesn't mean you're going to get those benefits till age 65. So I think it's just, setting those reasonable potential outcomes at mediation.
Yeah, it's very tough. One of the hardest things that, and I learned early on in my career, is like because clients will turn to you and say, okay, they're offering this amount. How do you, what approach? I'm interested in your approach for how you would say to a client, how do you talk with the client about, should you take this offer at the mediation or continue with your case? I always make it clear to the clients that it's their case, it's their decision, and I don't want to be one of these lawyers that's going to threaten you or kind of scare you into taking a deal. But I do want to, on the other hand, I want to give you realistic advice, some of it which you may not like to hear, but I have an obligation to tell you. So how do you handle it where if a client is unsure about taking the settlement offer at the mediation, how do you talk it over with them? Because one of the problems is with the mediation is it is a very emotional day. And what you want to avoid as a lawyer is a client taking a deal and then waking up the next day and having, they call it settlement remorse. So you feel like you've made a mistake, you were stupid, you got influenced, I can't believe I agreed to this. So how do you manage that with a client? Because it's a very challenging thing for lawyers and for clients alike.
Yeah, I think settlement remorse is reality. I think even in good settlements, and I mean, I don't have people coming back and telling me this. Most of my clients are very relieved, and they just say they're very relieved that this whole thing has just come to an end. But I think mediators, there's a lot of mediators that will say, you're going to leave thinking you didn't get enough, and the insurance company is going to leave today and think that they paid too much. And that means it's a good settlement. So, you only get your own side of the story. And, you might feel like, well, I don't know, maybe if I would have done something different, or we had another medical report or something else, I could have got more. And probably not. That's probably not the case. So some part of that is just normal, I guess. The way I assess it is I look and I see how strong is the case, how strong is the insurance company's case, and then I look at what a reasonable settlement amount. Sometimes, based on the evidence that we have, payment up until that date, like the date that we're showing up at mediation, might not be reasonable. It might be less than that amount. And for example, if there's certain medications that were not taken or certain treatments that were not followed, because everybody should make their own decisions that are right for themselves, and it might not be the right thing to do under the policy, but there's consequences. So for example, if there's certain medications that the insurance company would view it as being reasonable and customary in that case to take, but for your own reasons and your doctor's reasons, you don't think that the treatment or medication is the right way to go, that is a decision you should make with your doctor on a medical basis, but it might not line up with what an insurance company thinks is reasonable. So that could affect the amount. So looking at the evidence, sometimes often there'll be payments, some kind of buying out of your interest under the policy in the future, but that also means that you have no longer have coverage. So I talk with my clients and tell them, if you accept some payment for future amounts that, equivalent to future amounts, then you'll no longer be covered. So if you go back to work, let's say in 6 months or a year, you won't have LTD coverage. So is that something you're willing to accept? And some people are not willing to accept because they think that maybe in 6 months or a year, they'll be able to return to work. So it just depends. And then we have that conversation. There's always consequences, to any decision you make. So that's what I really try to talk through in every event. If you accept this is what it means. Sometimes clients will want to have a lower amount because they want that possibility of being able to return to work and not have that foreclosed on them. And sometimes for pension reasons or whatever it is. So it's all, there's no one reply to that question. I guess it depends entirely on the facts. And then that's what we walk through. And that's what your lawyer should be walking through, all of those different consequences to every decision you make.
Yeah. No, I 100% agree. It's very case by case. Sometimes you just don't have a strong case, and it doesn't mean you're a bad person, but there may be outside factors that influence that, and that can really affect the settlement value at these mediations. And we got a question here, Lisette. I'm going to pull it up, and I'll read it off, and then I'll get you to respond. So the question is, does being on CPP disability help with regards to insurance companies' perspective? Meaning, CPP disability has approved you as long-term disabled, etc. Does that bode well for a client in the context of a mediation or just getting approved for, well, let's just say in the context of mediation? How important is it that your client has approval for CPP disability?
Yeah, if it appears like you have a disability that will prevent you for the reasonably foreseeable future, that you won't be able to work, you should apply for CPP disability. And if you get accepted by Service Canada and you are receiving that information, it's very useful, but it's not determinative. So it doesn't mean as soon as you provide that to the insurance company that they're going to say, oh, okay, we give up on our defense and here you go, you're back on claim. They won't. And as I said, even in those cases, they won't reinstate your benefits. They'll be looking for a payout. And we know that CPP disability is an offset, so that's going to reduce the amount of money the insurance company has to pay you on a monthly basis. And there may be some money owing to them, depending how Service Canada, how CPP disability was accepted and whether the insurance company knew about it. So sometimes you can owe the insurance company money that you have to, which is good to check with a lawyer to make sure everything's done right before you appear at mediation. So there are times at mediation where we're dealing with paying some amounts back. And then the insurance company, what they'll say is, just because you're approved by CPP, by Service Canada for CPP disability, that's a different group of people. They have different criteria to meet. And so we don't know, maybe they didn't have the same documents we had. Right. Maybe there's information that's missing because it's a different process. It's different people assessing it and a different definition of disability. So they will argue for different reasons why that the decision might be different from what decisions the insurance company could have made. But it's definitely really good to be pushing them and saying, the insurance, the Service Canada, the government looked at this and they've accepted and said that I never will be able to work. And it's a very difficult threshold to meet. So it's whether you can do any work at all. But at the same time, and I talk to my clients about this, it doesn't mean the insurance company is just going to fold and say, oh, okay, since Service Canada has said that, then we're going to reinstate you and you're good and you'll get benefits till age 65, because
Yeah,
they
yeah,
don't have to
exactly.
accept it. They take it into account, but it's not a forced decision on them.
No. Overall, it is very positive for anyone wondering, like, bottom line, yes, getting approved for CPP disability does help. If nothing else, sometimes if you haven't applied for CPP disability, they'll be scratching their head and saying, "Oh, so you can't really be that disabled then if you haven't even got applied for CPP disability." Like, the insurers are very good to like flip it around whatever way works good for them. But I do like it. I like it just from a lawyer's point of view of having CPP approved because, again, when we're giving you estimates of settlement value of your case, we have to factor in that you may get approved for CPP in the future. So we have to back out whatever that money would be from what the LTD would owe you. And if we don't have the approval, it's not easy to figure out, well, what would your CPP be if it was approved? So you're able, as a lawyer, I'm better able to give numbers to a client once I know what the actual CPP is.
And you can call Service Canada. Let's say you're not approved, you're waiting for your approval, or you haven't applied yet. You can call Service Canada and get your estimated CPP
Yeah.
disability amount, which I will tell my clients ahead of time to get it for me. Otherwise, we may not be able to resolve at mediation. So that's a
Yeah.
very important piece of information to have.
There is an expert out there that we can hire who is a credible expert to be able to he can take your contribution history and run calculations and figure out like what would your CPP actually be. But for most people are not going to go hire an expert for that. And usually we don't either unless it's a very critical case. Now we got another question here, Lisette. This one is about what do you do if you have two insurance companies that work with CPP and mediation? So I think what this person may mean, if you've got two insurance companies or
To
maybe
insured.
two insured. If you have two insured, how will that work with CPP?
And
Maybe
mediation.
clarify there, Yusuf, if you mean you've got two insurance companies or two people. Two people. I'm not 100% sure there. We'll wait a second. We got another question here. This one is, how long can someone be on provincial disability? Is there a 2-year mark? I can answer that one quickly. So provincial disability is different province to province. So ODSP would be an example in Ontario, AISH in Alberta. Those do not have this 2-year kind of limitation like you would see come up with long-term disability. They also aren't necessarily limited to age 65. So you do have to look at your own province and see what the duration, but most of them do not have an end date in terms of they're not really tied to working age people. They're more like, for instance, for provincial disability, you don't ever have to have worked. They're not really tied to work so much as they are just providing income support. Okay, so Yusuf has, let me find my little thing here, two insurance companies. So how does this all change, Lisette, if you have two insurance companies? So you've got two LTD policies and you're going to a mediation, and let's just say both of them are disputing the case. How do you deal with that? Does that change anything?
I typically wouldn't go to a mediation with both insurance companies at the same time unless you're talking about short-term and long-term that are insured by two different people, which is different. So I guess it depends. If you've got short-term and you've got long-term and it's two different insurance companies or one is your employer, then sometimes we'll do mediations with all of the parties there at once. Sometimes if it's two different insurers, it's like some people have a private policy, for example, that they've purchased, which may be with insurance company X, and then they've got a group policy, which is with insurance company Y. I typically deal with those separately because there's different definitions of disability.
Yeah.
One is paid by you. You went out and applied for it. So it's very different than a group policy. So in those cases at mediation, they would be at two separate mediations. But I'm guessing because you're talking about one mediation, that it's kind of short-term and long-term, and they have different insurers. Typically, in those cases, you can either deal with it separately, or at mediation, just have all parties there. But the short-term insurer has a very small amount at issue. So usually sometimes it's for 20 weeks, sometimes it's for up to a year. But their payout amount is much smaller than the long-term disability insurer's amount. But we can deal with them both if they want to attend at mediation at the same time. Some of them will not agree to that.
Yeah, I agree with what you're saying. The short and the long term fit together. There may be a world where, in some cases, yes, maybe you would do the mediation with both LTD insurers, but for the reasons Lisette's talking about, it's not always your advantage to do that. You'd also would need a savvy mediator to really understand the area of long-term disability and insurance policies as well to manage a kind of a situation like that. You don't want to have a risk where you're getting kind of undercompensated because you've got two insurers that are each trying to get the other one to be the one to pay you more. So it's different in the world of automobile accidents. It's common in those cases where you might have multiple parties at a settlement, but it's all focused on the same damages owed to you. Whereas with LTD, it's like Lisette saying, it's very different things that are owed. It's not part of all the same kind of pot of money. So it's a little different there. Now we got time probably for one or two other questions. We're going to end here coming up on the hour. I don't know if there's any other questions that people have. Now would be your time to ask. Maybe I'll just finish with one question for Lisette, and then we'll see if there's any final questions from people. So what happens in a nutshell, Lisette? Let's say someone goes to a mediation and the case doesn't settle. What happens after that?
Yeah. There are times, I don't know what the percentages are, but most of them settle at mediation. Insurance companies only agree to go to mediation if they reasonably want to settle it. They're not going to waste their time, except of course in Saskatchewan is the exception, where it's mandatory and you show up early, and most of those do not settle. But if it doesn't settle at mediation, it doesn't mean that, everything's lost and nothing's going to happen. We, of course, have to continue on the standard rules of court and the process that it's moving towards trial, but it doesn't mean that it's inevitable that we'll end up at trial. Sometimes examinations for discovery or questioning, as it's known in some parts of the country, have been done before you go to mediation, which is an opportunity for the insurance company to test their case on you. So, of course, their theory is that you are not entitled to benefits, and they go to discovery, they ask you questions under oath where there's a court reporter, and your answers can be used at trial if we go to trial, or at mediation. Sometimes you'll see in mediation briefs quoting from discoveries, and they ask that information. And sometimes those discoveries, if it appears to us or the insurance company, or both really, that this is one that can be settled without having the expense to use the expense and time to go to a discovery, we might do the mediation beforehand. So if it does not settle, it is possible that the discovery will follow the mediation. Other things that can happen is you may, with discussions with your lawyer, you may decide to have an independent medical assessment done. If the insurance company, you really get a sense from mediation that they're not accepting your doctor's report and assessments, you might get an independent doctor to give an opinion. So that it is costly, it takes time, but that is one of the things that you may do. On the insurance company side, it is possible that they could They can do this before or after or at any time, but there could be surveillance. They could send out a private investigator to see what you're doing. So there's all kinds of steps, but generally, there can be other discussions about settlement between the insurance company and us, even though the mediation did not settle. And sometimes there's even offers that are kept open. Some mediators are better than others, but they'll say, look, you didn't settle, but this is where the insurance company was, and this is your position. Can you guys think about it for a week and talk, and we'll talk again in a week? So sometimes
Yeah.
it's left open. That is, insurance companies like having it finished on that day. So that's not as typical, but there's all kinds of steps, and there's always opportunities to discuss resolution or even go to a second mediation at
Yeah,
some
that's what I
point.
was going to say. You famously had a case where you went to a mediation and they said, you know what, you owe us several $100,000. And it was like, what the? So that didn't go very far. And then you successfully settled the case later on at a second mediation. So certainly there are two. It doesn't mean it's the end of the day if there's a mediation. If the mediation doesn't settle, it carries on just like Lisette said. Now, Lisette, we got another question here, and this might be our last question, unless someone gets one in here quick. I'll read it out here and you can kind of respond. To clarify, at mediation, does the client actually have to speak? Okay, yes, we should have covered that. To the insurance company or to their own lawyer, or will their own lawyer do all the talking or speaking? So does the client have to, what does the client have to say? Do they have to do a presentation? Are they going to be put on the spot with questions? What
Yeah.
does a client have to speak at the mediation?
Yeah, that's often a question I get from clients. I do almost all of the speaking at mediation to the insurance company. Um, you do not, you just, you as the person at mediation, you might just have to say hi and my name is at the start of it. Or if you're really concerned, just let your lawyer know and they can present you and just say, this is so and so attending mediation today. That's perfectly fine if you don't want to say anything at all. And typically, I tell my clients to not say anything. I'll say, if please take notes and write down what you disagree with or that is significant that you want me to know. But when the insurance company is there, unless my client wants to, insist, but I say it's probably better that you do not. We're not there to resolve all the little points. We're looking at it on a global basis. If the parties can resolve it, so they may say something that's infuriating to you in the opening statement, and it does not move it forward by you responding and saying that was wrong, you got it wrong, that's not true.
Or huffing and puffing and saying, like, making gestures, and you're better off just to be like a poker face.
Yeah, or thinking this is never going to resolve because all they've said is all these terrible things that I'm able to work and I'm not disabled and all that. So I just tell my clients, make notes and we can talk about it, and the mediator can present your statement. So there's really nothing for the client to do. And I get that question a lot.
Yeah, I would say, like, there is some talking. So when you, as Lisette described, let's just say you're on a Zoom mediation and they put you in separate rooms. So you'll be in your own room with the lawyer. Now, the mediator does come into that room with you at times, and sometimes it's okay to, the mediator will ask you questions, and it just depends on the day. Like, if sometimes it makes sense for you to answer questions that the mediator might have. Sometimes it's better maybe to discuss with your lawyer before you answer those questions, just to make sure that you're answering it the right way. But that there's a talking, and it's a long day, so there's a lot of talking done in the private rooms. And when the mediator comes in, that's a time where you can maybe answer some of their questions and things like that. I really prepare clients, especially in Ontario. For whatever reason, Ontario can be very confrontational at these mediations. It's kind of a culture there. So it's not uncommon at the start of mediations in Ontario for these opening statements. For some other lawyers, can be quite insulting. I don't know if they're doing it to try to get to see, can I rattle this person, that if they're just trying to look tough for their insurance company client. So I don't always know what the motivation is, but some of them can say very insulting things. It's not really conducive in my mind to, like, getting a settlement done. Now, that's not all the time, but I prepare clients for that, that might happen, and that you just want to remain calm. You don't want to respond in kind, and it will usually, that just kind of looks bad on them in my mind in terms of the mediator as well, when they just are saying kind of very negative things about you, or in the opening statements. Okay, I think that's it, Lisette. I'm going to let you get on with your Friday here. I want to thank everyone for coming. I'll just let me just hide that up. So I want to thank. I'll let Lisette go. Thanks for coming, Lisette. Hopefully, we'll have
Okay.
you back on a future episode to talk about something else. Now, for the rest of you folks, thank you for attending for the mediation today. If you want more information, I think it's in the description of this video. You can get in touch with our firm if you have questions. I'd also encourage you to get a copy of my book, Step-by-Step Guide to Winning Your Long-Term Disability Case. That's a new version that just came out this January. It's available free on our website for download. We also will mail you a copy. It's for sale on Amazon as well, but we'll also give you a free copy if you get in touch with us. I will sign off now. We'll see you on Monday. Like I said, on Monday, Tuesday, Wednesday, Thursday next week. We'll be back here again. Take care, folks.